40 years old and you're doing this nonsense in our jail? This is the stuff, this is the stuff that I keep reading about the young ones in our jail. Not that being in jail is a role model, but you're old enough to be there and say, look, I'm doing better. Do better there. Encourage others to do better. Encourage the younger ones to do better. Don't encourage them to do worse. Doesn't look like you like following the rules is what this appears to me to be. And so here's the thing. If you're not on a felony probation ×3, you can do whatever you want. You can run around your house naked. You don't have to wear your jumpsuit a certain way. You don't have to follow anybody else's instructions. But when you're on felony probation, you have to follow rules that you may or may not like. You have to be respectful to people who are in charge of you, who are just doing their job. Your probation officer and out at the jail. And how old are you? Kay Broussard and Mr. Nix, will your client waive the formal reading of the motion in each case?
She will, Your Honor.
Broussard, in cause number 19-32806, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 21st, 2020 for the second-degree felony offense of assault on a peace officer, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
And then in cause number 19-32518, I also have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 21st of 2020 for the offense of escape while arrested or confined, a third-degree felony, and that was a 10-year deferred probation as well. Is that correct?
Yes, ma'am.
And then finally, in cause number 21-36615, I have a motion to revoke your unadjudicated probation. This shows you were placed on probation July 12th of 2021 for the state jail felony offense of possession of a controlled substance, and that was a 5-year deferred probation. Is that also correct?
Yes, ma'am.
Each of these motions allege that you violated your probation. Count 1 in each case alleges that you failed to report as directed to the probation department March 18th of 2025, and is that true or not true?
Yes, ma'am.
True or not true?
True.
Thank you. Count 2 in each case alleges that you failed to immediately report to the probation officer your 2024 tax return documents, and is that true or not true?
True.
And then finally, count 3 in each case alleges that you were behind in your court-assessed fees. Is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're all actually true?
Yes, ma'am.
In each of your cases, I have here on the computer some documents that have your signature on them with Mr. Nix that shows that the district attorney's off. Well, let's see. All right, so before you went over these, did you, good grief, before you signed these, did you go over them with Mr. Nix?
Yes, ma'am. I did.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made in all of your cases, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement is to continue you on probation, to order as a condition of that probation that you enter and successfully complete the cognitive track of the ISF program. And
Computer was being a little temperamental. What that is intended to say is that she's in good faith going to pay the money that she has up front via her family, the $2,040 as a good faith effort towards her fees.
okay, and so you have that $2,040 now, and somebody's going to get that paid.
I do, Your Honor. They brought it to me in cash, and I'm going to write a firm check for the actual amount as opposed to handing them cash.
Sure, okay. And that's your understanding of your agreements in all of your cases, is that correct?
Yes, ma'am.
And let's see, it looks like this one did the same thing. When you're done, Mr. Nick's signature's not coming through. What a fun day with technology. Oh. Did I do that? I could have done that. That could be me. All right, so state tenders number 1 in each case?
No objection.
It's admitted in each case. Is there any evidence that Ms. Broussard's not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 in each of your cases freely and voluntarily. Find those counts true. find sufficient evidence in each of your cases to find you guilty and revoke your probations, but I'm not going to do that. It sounds like probation's here, like everybody wants to work with you so that you can be successful on these probations. So you need to really go to ISF, learn the tools that'll help you make better decisions so that when you get out, you still have no felony conviction on your record.
Judge, based on Ms. Johnson's request and some interactions with Ms. Broussard, as
Uh-huh.
well as those jail incidents, when you might want to fill the court in a little bit more, she needs a little bit of admonishment on her aptitude.
Okay. Is there some jail, do I have some jail reports on this one?
Have them here, that would be helpful.
Well, I think I probably went through them
Here's the
yesterday.
latest one.
That's okay, I've got them right here. Thank you. Mm-hmm. So it does, there more that I need to know about?
No, ma'am. That's pretty much how it's been is, with the attitude, it's following instruction. And when we give her instruction, she usually gives us some pushback. So yes, that's pretty much the
Okay.
whole.
So this is your second opportunity.
Yes, ma'am.
You're not going to get a third opportunity.
Yes, ma'am. I understand.
In one of these cases, just one of these today, I could send you to prison right now for 20 years.
Yes, ma'am.
Today, I could do it right now. I don't have to take agreements on these motions. I can do whatever I want within the realms of the law and the realms of the terms on each case.
Yes, ma'am.
2 to 20, 2 to 10, up to 2 years.
Yes.
I could do all that right now today. If you continue to be disrespectful to your probation officer or out at the jail, then you're going to be back in here and it's not going to be nice. Do you understand? I don't care if you have young children. I don't want to hear any excuses. Oh, be nice next time because I have young kids or I need to be there for somebody. Change it, change your behavior so that you can take advantage of this opportunity.
Yes, ma'am.
Okay,
I'm sorry, Ms. McCarran. I apologize.
thank you. All right, then, I'm going to, again, continue you on probation, order that ISF in each of the cases, and then when you're out, as soon as you get out of ISF, go straight to probation and continue that probation, hopefully successfully, so that you can finish it, get off of it, and not have any convictions.
Yes, ma'am. Thank you.
If I
Yes.
can have one thing,
Uh-huh.
and even though it's not part of the agreement, it's everybody's understanding, when she gets out, she's gonna bring her tax return, which is one of the violations.
That's required.
Yes,
So-
ma'am. I'll follow you around.
Okay.
We do,
So it's not that hard to do.
online. Yes, ma'am.
So when you do it, it's just another one of those things. Follow the rules.
Yes, ma'am.
Uh,
I sent it to.
hang
her.
on, listen, just, you need to do everything that you're supposed to also on probation's time frame
Yes, ma'am.
and not your own.
Yes, ma'am.
All right, so it's very important when they ask for something, get it done immediately. When they ask for it, not sometime future, don't make them ask for things over and over again, all that kind of stuff, okay?
Yes, ma'am.
I'm going to hand you in just a second, hopefully, the trial court certifications in each of these cases that shows these were agreements that I followed, and so you've waived your right to appeal. I don't hear anything happening though. And at least, let's see, hold on that first one, the second one's fine. The first one needs Mr. Nick's signature. And let me check the third one. Did two print or just one? So that's 06. So I need, I'm about to do 15. And none of y'all's signatures came up on this right to appeal, but I went through it with her, so I'm going to sign into it. Is this all because of the update? Or what is happening?
I don't know. This is the type of problem we had last week, or yesterday and last week. Things just disappearing.
Okay, here's those documents, Mr. Nix.
Judge?
All right, good luck to you, ma'am. And thank you for being, good morning. Are you Lawrence Marks?
Yes, ma'am.
And Ms. Peraza, will your client waive the formal reading of the indictment?
You will, Your Honor. Are you ready? Thank you.
And are we going on count one only?
Yes,
It doesn't really affect anything, but yes, Your Honor.
Okay, I'm getting there. Mr. Marks, in cause number 24-1763, the state's elected to proceed on count one only. It alleges you committed the second-degree felony offense of aggravated assault with a deadly weapon, and that is from July 31st of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? Speak up, please.
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Peraza?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Marks is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and that you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon, sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am making an affirmative finding of a deadly weapon. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Peraza. Good luck to you, sir. You can go back with the bailiff. And do you have Johnson's paperwork? Avion Johnson?
It was on the tab, I think, so I signed it.
He's already been ready.
Go off for just a second.
This is, are you Avion Johnson? Come on over to the center, Mr. Johnson. And Ms. Peraza, will your client waive the formal reading of the indictment?
You will, Your Honor.
Mr. Johnson, in cause number 24-2044, you're charged with a first-degree felony offense of arson intending damage to a habitation or a place of worship from August 1st of 2024. And how do you plead to that charge? And are you pleading no contest freely and voluntarily? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Peraza?
Yes.
Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. Any fine?
No fine, Judge.
Is there restitution?
We're gonna I don't believe there is any. It doesn't appear that there is, that has not been already satisfied, but just to be on the safe side, we'll take a look at that.
Okay.
And see the PSI if we may.
All right, is that at your understanding of your agreement? Do you also understand that if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Johnson is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of no contest freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report, and that'll give me more information about you, your case, and then we will come back at a later date for sentencing. All right, you can go back with the bailiff.
Thank you, Your Honor.
Yes, ma'am, thank you.
Thank you.
See, Ms. Holmes, you have Christina George. What are we doing on that?
Yeah, that's the one with the safe P.
Okay,
So, I guess could we reset a couple of weeks, I guess, to see if Horn County can put the hold on her? and
yes,
Get her.
that would be very helpful. Yeah,
Yes,
let's
ma'am.
reset Ms. George 2 or 3 weeks.
Okay,
And then Ray LeBlanc,
yeah, we're ready on that.
is there paperwork?
Yes,
Okay, I don't have that yet, so hang on just a second.
there he is.
Okay.
Take your fingerprint. You have Jennifer's number for life?
And what are we doing on Kendrick Williams?
I'm still working.
Okay. Yes, ma'am. Okay.
Excuse me.
Good morning. Are you Ray LeBlanc?
Yes, ma'am.
Can you hear me okay like that?
I can hear you.
Okay. And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. LeBlanc, in cause number 250460, you're charged with the state jail felony offense of burglary of a building from February 5th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily,
Yes, ma'am.
and because you did what they charged you with?
Yes.
I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
Do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And are you a U.S. citizen?
Yes, ma'am.
Okay.
You're a U.S. citizen.
Oh, yeah.
Okay. I have to ask everyone. State tenders number 1,
No objection.
it's admitted. Is there any evidence that Mr. LeBlanc is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of burglary of a building. Sentence you in accordance with your agreement to a term of 6 months in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, so you've waived your right to appeal. I am also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition.
Okay.
Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices I'm required to read it to everybody.
I'm never on the firearm on my lot.
I've got to say all these words, sorry. So you should read that to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. Good luck to you, sir. Thank you, Ms. Holmes.
Yes, ma'am, thank you. Okay, so, yes, so they have you on the docket today in Mr. Court, your attorney's name is Jennifer DeLay. Okay, so I'm going to contact her to make sure she comes back to see you. They're going to tell them to bring you over to county court right now.
See, Mr. Lewis, you have Derek Ardwan.
Yes, ma'am. I'm telling them to bring you over to county court right now.
Thank you.
Derek Ardwan. Morning. You've been back there working. You got them piled up today.
Let me get
Looks like a gold star in the making. I don't know yet. We'll see.
I'm working on it.
What?
Why does he get a gold star?
Because he's got 3 pages of docket that he's taking care of.
2 of those are mine.
Okay, so y'all can share the gold star.
Majority of that, one part.
Good morning, sir. Are you Derek Ardwan? And will your client waive the formal reading of the indictment?
He does.
Mr. Ardwan, in cause number 250350, you're charged with the second-degree felony offense of sexual assault, and that's from July 15th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney, you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a cap of 6 years in prison, which means if I accept this agreement, you're leaving your punishment up to me. And I cannot give you more than 6 years. I could give you 6 years, I can give you less. It'll depend on the information that's brought to me at a sentencing hearing. You have an absolute right to have a jury come in and determine 2 things. The first is to decide if you're guilty or not. And then if they find you guilty, you can leave your punishment up to them. If we go forward this way, you're waiving that right. And is that what you want to do? Also, do you understand that if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Also, as a result of this plea, it looks like you have gone over with your attorney that you will be required to register as a sex offender, and it looks like you've already signed that document and those admonishments. Is that your understanding as well? State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Ardwan is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Lewis, and he will present it to me on your behalf when we come back. All right? You can go back with the bailiff. See, Colton Armstrong,
That one, Judge, I think Bruce Smith filed a motion to set up this morning.
oh, just this morning? Great. Looks like Colton Armstrong's going to be reset. If you'll make a notation that he's supposedly hired Mr. Bruce Smith this morning, and then so we can be kind of watching for a letter. James Burrell, Mr. Lewis.
Yes,
Good morning, sir. Are you James Burrell?
Yes, ma'am.
And Mr. Lewis, will your client waive the formal reading of the motion?
He does, Judge.
Mr. Burrell, in cause number 22-39838, I have a first amended motion to revoke your community supervision. Shows that you were placed on probation May 23rd of 2023 for the third-degree felony offense of theft, and that was a 10-year term in prison that was suspended for 10 years. Is that correct? The motion alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department May 14th, May 23rd, June 11th of 2024. And is that true or not true? Count 2 alleges that you failed to immediately report to your probation officer your change of address and phone number. Is that true or not true? I'm sorry? Okay.
I think the state would be willing to waive counts 3 through 5. However, we could be asking for some sort of plea on 6 and 7.
All right, so the state's going to abandon 3 through 5. Count 6 alleges that you were arrested for the offense of possession of a weapon by a felon June 19th of 2024 in Orange County, Texas. And is that true or not true? And then count 7 alleges that you were arrested for possession of a controlled substance June 19th of 2024 in Orange County. Is that true or not true? Did you enter your pleas of true to, I'm sorry?
No.
I thought I was going to say.
No.
Did you enter your pleas of true to counts 1, 2, 6, and 7 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Burrell is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, 6, and 7 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation, reassess your punishment in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. I went over that with you back when you first got probation, right? So just make sure you read that and know that because of this judgment, you cannot possess a firearm.
Yes, ma'am.
All right, good luck to you, sir.
I thank you. Thank you, Ms. Lee.
Yes, sir. We had to bench warn him, so he got some times, I guess, from Orange to 2, 6.
You said the no.
You got a rep.
Mr. Lewis, you have Eddie Garcia Aragon. That's a sentencing.
Judge, I know for the PSA that he has the ice hold and a deportation detainer. I don't know if the plea, if we need to revisit maybe doing a 1244.
Yeah, I'm not inclined to give a probation to someone that obviously is here illegally. So, what I can do is reject, once he comes out, I'll reject it. Y'all can get some new paperwork, renegotiate what you want to.
Based on that detainer, would the court be willing to accept the 1244?
For this offense and the, like, yes, like history here, that's fine. Good morning, ma'am. I'm sorry you've been waiting so long. I didn't even realize you were here for that, and I saw you sitting out there. You need to wave me down and say, take care of my stuff. Would you please raise your hand? Do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English, so help you God?
Yes, ma'am.
Thank you. And sir, are you Eddie Garcia Aragon?
Yes.
And Mr. Aragon was previously in court, entered a plea of guilty to burglary of a building. I've received the pre-sentence report, and part of that report has given me the information that Mr. Garcia Aragon is not here in the United States legally, and that there is a current hold for immigration on him. And because of that, I'm not going to accept the plea agreement for probation. So at this time, I'm going to reject that plea agreement. I'm going to hold the case for a few minutes. You guys can go back and visit and see if there's something you want to work out different this morning. We can get it taken care of while Ms. Burge is here if possible. Okay. And then Desron Roberts, Mr. Lewis. You good over there? I feel like it should be later than 10:30.
I know, I looked up, like, it's.
Like, I feel like we've been here for a long time. Good morning, sir. Are you Desron Roberts?
Yes, ma'am.
And Mr. Lewis, will your client waive the formal reading of the indictment?
He does, Judge.
Mr. Roberts, in cause number 241821, you're charged with the state jail felony offense of possession of marijuana from December 4th of 2023. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes,
And are you pleading guilty because you actually did what they've charged you with?
yes,
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
yes, ma'am.
Do you fully understand them?
Yes,
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
yes, ma'am.
And it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
I have to ask everyone that question. State tenders number 1,
No objection, Judge.
it's admitted. Is there any evidence that Mr. Roberts is not competent?
No, Judge.
And is there any history?
There's misdemeanor history, Your Honor. There's no felonies, although there is one pending testing that looks like it'll end up as a second-degree possession of methamphetamine. Testing's not yet been completed, so no case has been brought to our office.
Okay,
I'm just looking at his record, and I don't know any other circumstances of the case other than it shows a likely second-degree possession. I would assume that'll end up as a probation concur with this, but I don't have anything else.
all right. So I think what I'll do, just to make sure we have that all lined out and possibly give them time to get that done, is I'll get a PSI, but I'll do something on the
It
bond.
was an April arrest, and on the lab portal, it just says testing pending.
Okay.
Doesn't have anything done yet.
All right, so, I'm going to, where did I stop when I started asking about that? Too many words today. Did I already tender number 1? Did we already do that?
We did.
Okay, so what I'm going to do, Mr. Roberts, is based on your plea agreement, I'm going to reduce your bond in your case to $1,000. I'm going to make that a personal bond, which means you don't have to pay any money. You're just going to get out of jail, but there's some very important things about that, all right? So the first thing is that as soon as you're released from, it's a big smile going on, that's good. Hopefully you'll stay smiling, you'll do everything you're supposed to, and how old are you?
26.
26.
27 next week.
Okay, so you're gonna change your ways, right?
Yes, ma'am. I have to.
All right, so
Yes.
yes, you need to then, for sure, for yourself and for them. So, the first thing you do when you're released from custody is go to the probation department, because they're gonna do a pre-sentence report. You've got to do an interview with them, and if you don't go do that, then when you come back, you run the risk of me raising your bond, going back to jail, and me not accepting this agreement. You understand?
Yes.
Also, if you are arrested for anything between now and when you come back, you obviously run the risk of me not accepting this agreement. The last thing is I am going to require, as a condition of your bond, that you wear a drug patch. All right, you have 24 hours from the time you're released to get that drug patch on. And then you need to get proof of that to Mr. Lewis. Since I don't have a bondsman, I'm going to have Mr. Lewis get that information and then get it to us so that we know where he has it and we can contact them and they can send us the results. So a drug patch is going to be on your arm. You go every 2 weeks and you get it changed. If it tests positive and it shows me you're using drugs, obviously we're in a whole different situation. Okay?
Judge, Mr. Roberts turned down an option that would probably get him out in the next few weeks. And I think the idea was to prevent himself from becoming a felon.
Good.
And so with that in mind, I think I'm hopeful that he is committed to straighten his life out.
That's good to know, because sometimes people will just take a short amount of time to get things over with.
I wanted the probation in order to keep myself clean.
Yeah, keep yourself clean and keep a felony conviction off your record. Now, obviously, there's another case that's out there, it looks like, from some time ago. Once that's filed, there probably will be a warrant. You'll have to go turn yourself in. We'll get it sounds like another probation that'll run with this one, but you're going to have to go through that process as long as you're doing everything right while you're on this probation until that comes, right? Okay, we'll see you back at sentencing.
Okay,
Yeah, I remember approach on,
Yeah, and Mr. Lewis, if you want to go maybe work on Mr. Garcia while Ms. Burge is still here, and I'll hold your other ones. And who'd you want to, yes,
so, I think I have a conflict. I represent the co-defendant,
oh,
but on the CPS side, it's because of this case, the cases though, the injury to a child
oh, yeah, I
cases.
would think that would still
And
probably,
Barbara represents the co-defendant here, but I think there would be a conflict with me using the co-defendant.
Sure.
if Ms. Holmes on.
absolutely.
Yeah.
Okay, so let's do this. I'm gonna, based on that information, I'm going to release you, Ms. Holmes, as the lawyer for Mr. Williams. Let's get one of ours, either Mr. Parker or Mr. Rojas, appointed today, and then they can, if you'll get whatever you have to them,
Yes.
and that way we can get it moving along that way.
Okay.
And it looks old, Judge, by age, it is, he was at large quite,
Okay.
almost a year before the,
Got it.
sent the marshals for him.
All right, thank you very much.
Okay.
Thank you, Ms.
Yes,
Holmes.
ma'am.
And so Mr. Williams can go back. So now it's just Mr. Lewis. Now that I'm looking at it, I probably could have just changed the plea agreement, but we'll go through the whole thing. All right, this is cause number 240282, and again, you are Eddie Garcia Aragon,
Yes.
and will he waive the formal reading of the indictment?
He does, Judge.
Mr. Garcia Aragon, you're charged with a state jail felony of burglary of a building from January 21st of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they charged you with?
Yes.
I have on the computer some documents that have your signature on them that the state's marked as Exhibit 1. Did you go over these with Mr. Lewis before you signed them?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you'll be waiving or giving up any right to appeal.
Yes.
Also, do you understand, if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, I understand.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Garcia Aragon is not competent?
No objection.
I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the consequences of your plea. Find sufficient evidence to find you guilty. And at this time, find you guilty of burglary of a building. Sentence you in accordance with your agreement to a term of 1 year in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. Shows that I followed the agreement. So you waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. That admonishment is in Spanish. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Make sure you read that to understand the law. And if you have any questions about that, you can ask Mr. Lewis. All right, good luck to you, sir. Thank you. Thank you, Ms. Bursch.
Excuse me, Judge. Mr. Garcia did want to address the court.
Okay.
Yo me siento apenado de todo esto, ¿verdad?
I'm extremely embarrassed for what I have done.
No supe actuar, hice las cosas mal.
I didn't know how to act.
Yo vine aquí a Estados Unidos a trabajar para ayudar a mi familia.
I came to the
Cometí un
U.S. to
error
work and to help my family, and I made a huge mistake.
y le pido disculpas a todas las autoridades y a la persona que me mandó.
And I would like to ask for your forgiveness, Judge, and to everyone in the court, including the officers, and to the person that I committed this crime against.
The person that you committed the crime against is really the one
Dice la persona que cometió el crimen.
that you owe an apology
Es a
to,
quien le debe más bien la
because
disculpa.
they gave you a job
Me
Porque le
siento,
dieron un trabajo
and then you stole from them.
igual,
y le robó.
okay. Igual me siento apenado porque Estados Unidos me recibió acá para venir a trabajar y mi intención no es venir a hacer daño a Estados Unidos.
He said, I understand, Judge. I'm extremely embarrassed because the U.S. gave me an opportunity and I did not know how to take advantage of it.
Thank you, sir.
Gracias. Bye.
Justin Thomas, Mr. Lewis.
Yes, ma'am.
Good morning. Are you Justin Thomas? This is cause number 250308. I am going to take judicial notice of the court's file. Mr. Thomas was examined for competency to stand trial by Dr. Grapon. I received that report dated May 29th of 2025. The finding in that report is that Mr. Thomas is currently not competent to stand trial, and that inpatient treatment would be warranted for competency restoration. Is there any other evidence with regard to competency?
No evidence from the defense judge other than Mr. Thomas did want me to have it noted that he did not agree with Dr. Goupon's decision.
All right, thank you.
I'm gonna stay here.
All right, then, Mr. Thomas, at this time, based on that report by Dr. Gopon, I am going to find that you are not currently competent to stand trial. I'm going to order you to the appropriate facility for competency restoration for a period of not to exceed 120 days from the date you get to that facility. I would advise you to cooperate with any doctor's orders, medication, treatment, so that we can get you back here and get your case taken care of once you've regained competency. All right, you can go back with the bailiff. You just need to go back with the bailiff. Once you get competent, we'll take care of that.
All y'all have to do is access the video yourself.
Okay.
He said I was one of the only persons that ever talked with a competency. Oh.
Go home back with it.
I've been trying to say that, bro.
Trevante Ville. All right, sir, are you Trevante Ville?
No.
And in all of Mr. Ville's cases, I'm also going to take judicial notice of the court's files. Let me get one pulled up that has it. Mr. Ville was previously found not competent to stand trial, was sent for competency restoration. We have received, oh, that's not it. Here it is. All right, I've received a packet from the University of Texas Health Science Center, John Dunn facility, dated March 20th of 2025. That includes a trial competency evaluation report. In that report, it does show that Mr. Ville has attained competency while he was there. And is that all? Also, I received the attending physician's report for the letter to the court, and that was prepared by Dr. Nubia Liberis, also with the summary of the competency restoration and the opinion that Mr. Ville is currently competent to stand trial. Is there any other evidence with regard to competency?
No, Judge.
Mr. Smith? Then at this time, based on that, I am going to find that Mr. Ville has achieved competency and is currently competent to stand trial. Mr. Lewis, will he waive the formal reading of the indictment in all of his cases?
He does, Judge.
And are we going on count one in all of them?
Yes, Judge.
Mr. Ville, in clause number 24, DCCR 1933, the state's elected to proceed on count one only. It alleges you committed the third-degree felony offense of harassment by a person in a correctional or detention facility from July 5th of 2024. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
So all going kind of slow. And then in clause number 24, DCCR 2061, the state has also elected to proceed on count one only. It alleges that you committed the third-degree felony offense of harassment by a person in a correctional or detention facility from August 20th of 2024. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
And then And cause number 25, DCCR 0025. The state has elected to proceed on count one only also. It alleges you committed the third-degree felony offense of harassment by a person in a correctional or detention facility from October 30th of 2024. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And because you did what they charged you with? Clause number 242445, you're also charged in count one only with the third-degree felony offense of harassment by a person in a correctional or detention facility from October 9th of 2024. And how do you plead to that charge?
Good.
Again, are you pleading guilty freely and voluntarily?
No.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
And then finally, in cause number 241418, you're charged with the third-degree felony offense of attempt to commit assault on a peace officer from June 2nd of 2024. And how do you plead to that charge?
Good.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
In all of these cases, I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them? I need you to answer out loud, please.
Yes, ma'am.
And do you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
So if I follow the agreements, you can't change your mind later. Do you understand?
Ma'am.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objection, Judge.
It's admitted in each case. All right, Mr. Veal, I'm going to find in all of your cases, again, that you entered your pleas of guilty freely and voluntarily. Make that finding that you are mentally competent and that you understand the nature and the consequences of all of your pleas. Find sufficient evidence in each case to find you guilty. In cause number 241418, find you guilty of attempt to commit assault on a peace officer. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 242445, find you guilty of harassment by a person in a correctional or detention facility. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 250025, finds you guilty of harassment by a person in a correctional or detention facility. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 242061, finds you guilty of harassment by a person in a correctional or detention facility. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then finally, in cause number 241933, find you guilty of harassment by a person in a correctional or detention facility. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will all run concurrently, which means together at the same time. I'm handing you, in each of your cases, the trial court certifications that shows that these were agreements that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Lewis. All right, good luck to you, sir. You can go back with the bailiff.
Good morning, Your Honor.
More, Your Honor.
Good morning.
No.
Good morning, sir. You Brian McWade?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Yes, Your Honor, we're pleading to the lesser included attempted.
Thank you.
Just need to see, make sure that.
Okay, I'll be sure to add it.
Mr. McWade, in cause number 26 DCCR 0402, the state has elected to proceed on the lesser included offense of a third-degree felony, attempted aggravated assault with a deadly weapon, from March 8th of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Macon?
Yes, ma'am.
Do you fully understand them? Yes or no?
Ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for an 8-year deferred probation. No, I'm sorry. There would be an 8-year term in prison that would be probated.
Which I
for
believe
8
we
years.
can do since it's an attempt, Your Honor. Typically with this offense, you
Right.
can't, but I think since we made it an attempt, we're okay.
Okay. Y'all looked at it
A
a little bit.
little bit, yes, Your Honor. That's
Okay.
my understanding.
All right. So, what we'll do also is between now and sentencing, if everybody will double check, just so that we make sure before sentencing that we don't do something that we're not supposed to.
It's in that big green book, I think.
I'm sorry.
It's in that big green book.
Yeah.
The big green book.
The big green book. All right, so it looks like the agreement is for an 8, you would be convicted with an 8-year term in prison. That would be probated for 8 years. There would be a $1,000 fine, and you would be required to follow all of the rules and conditions of probation. It's checked off restitution center,
There is restitution involved, Your Honor.
but not the restitution. We don't even have that anymore. We need to change that. We don't have a restitution.
Saw the word
center.
restitution and check the box.
So there's an agreement, I'm gonna write, that you would pay restitution, is that correct? And the amount determined between now and sentencing?
Yes, Sean.
Is that, you understand that as well? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection, Your Honor.
It's admitted. Is there any evidence that Mr. McWade's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back for later for sentencing. That'll also give everyone an opportunity to figure out that restitution amount, and we'll double check that based on what the nature of this offense is, that we can do that convicted probation. I want everybody to double check that as well. So with regard to a bond based on the nature of this plea agreement, Mr. Nichols, what's the state's?
Your Honor, he served 150 days in jail for this case. We don't oppose a bond pre-sentencing.
So, Mr. McWade, what I'm going to do in your case, based on the nature of your plea agreement, is reduce your bond to $1,000. If you make that bond, there's a couple of things that are very important. The first is that you go directly to the probation department when you're released so you can get that pre-sentence report done. If you don't do that, you run the risk of me not accepting the plea agreement, and things could be worse. Also, if you are arrested for anything between now and when you come back for sentencing, you run the risk of me not accepting the plea agreement. And then the last thing would be a condition of your bond is that you have absolutely no contact or communication with Simone Mullins. That's obviously communication in person, but it's anyway, you can't send messages through any type of social media or other people or anything like that. If you do, and I find out about it, then your bond will be raised, you'll be back in jail, and I probably won't accept the agreement. All right, any questions? All right, good luck to you, sir. You can go back with the bailiff. We'll see you at sentencing.
Thank you, Your Honor. Ms. Megan.
Could you please make a note? Because I feel like I'll probably be on that. Take some of all the emotions. Your name, I'm guessing, Maria. To remind me, and I can ask Ken to help me out with that. Yeah, give me 1 second. What you got?
I'm in trial next door.
Okay,
And we can really get started in a minute, and I think Tommy has some redacted stuff for me to look at, so I need to get over there.
okay.
But, the
You have a
pre-trial,
lot of them. over
I
there.
know, the pre-trial case that I had that's on the trial docket, Josh Smith,
Okay. Yes,
Mr. Smith just gave me a new offer that's gonna resolve that matter. I just
Okay.
need the time to do paperwork and everything to get it done. It's gonna be a probation plea.
okay.
I don't know about it done today, but if we can do it if there's some available next week.
Well, no, well, we could do it Wednesday of next week. Or we could do it early tomorrow. No. Let's set it for a plea Wednesday morning of next week.
Yes.
Joshua Smith, well, so all of Mr. Lewis's are we set now? Okay,
Sorry about that.
that's okay. We could have not brought them all over, which we know. Okay, but that's fine. All right, so I will set that one though for a plea on Wednesday morning. Yes, sir. Well, that just, no. We may need to have like a. No, that's okay. Maybe we can look at all of those that are based Mr. Smith's, who's gonna have to be here Wednesday anyway. Of next week. We're setting some of those to that is have so many. And it's. I don't know if there's, you know what I mean? And then spread them out a little bit. Okay, that's, Mr. Kelly, you got Dondre at Blewett.
Yes, sir. Thank you.
Morning.
That's gonna go into effect in 2 months. I guess not.
I've asked Mr. Coleman from the scope of it. Yes, I responded.
What did you think?
Your complaint witness that we stood like recently.
Not worried now.
Good morning, you're Dondre Blewett.
Yes, no.
And Mr. Blewett's case in cause number 26 DCCR 0362 set for trial to begin with jury selection on August 17th. And what is the announcement?
Your Honor, I recently asked Mr. Coleman for some additional discovery involving a complaining witness. I sent him an email on. This was Thursday, the 30th. I haven't heard back from him yet. I think it's pertinent to our case because of what it involves a complaining witness. So until I have an answer on that, I don't think I can make an announcement.
Mr. Nichols,
I show that some reports were added back in April, but nothing in the last week, so I'll have to check on that, Judge.
Okay.
I don't mind chasing him down. I know he's not in your court anymore. That's good.
Yeah, we're working on some of those issues. So why don't I do this? I'm just going to probably, I'm not going to reset it at this point. If you can get with Mr.
got time,
Coleman,
Jason.
we've
I
got
can
2
submit
weeks for you guys to, yeah. if you'll kind of help out with that, get that information to Mr. Kelly, and then kind of let me know where we are. It's not the trial oldest one, but others are kind of falling apart, so you never know. Yeah, so I'll number it, but I'll also make a notation of that. Thank you,
Thank you.
Mr. Nichols.
Sure, thank you.
You can go back with the bailiff.
I was supposed to give him a list.
And is that one that he and Mr. Coleman intended on keeping?
It originally was, yes, Your Honor. We can handle it.
Okay, thank you.
Looking back, I was just grateful.
Mr. Burbank on Kavon Saunier?
I guess they're all back.
They are. I hope he is.
Let's talk with, yeah. Just so they pick it up.
Thank you. I appreciate that. How are you this morning?
I am in a jury trial in CC today.
Hmm. All right. Good morning. Are you Kavon Saunier?
Yes, ma'am.
And Mr. Saunier's case in cause number 25 DCCR 1530 is set for trial to begin with jury selection Monday, the 17th of August. And what is the announcement?
Judge, the state's ready. On the 16th of July, I filed a notice of intent to use business record affidavit. There's about 1,200 pages of medical records that have been added to discovery a few weeks ago. I'll, in candor to the court, we'll have to proceed most likely without the complaining witness. And that's how we're going to be presenting this case.
Okay.
So we can be ready.
Okay. Sounds good. And that was done a few weeks ago.
I believe the 16th was when it was filed.
Okay. Mr. Burbank?
Your Honor, if you would call the 260th court, I do have a trial set. In Judge Raquel, it's a murder trial.
Okay.
And I can be ready, whoever wants me.
Okay, sounds good. I'll look at our numbering on this one and take that into consideration. And if for some reason it looks like you're at the top, I'll see how old that one is and things like that, and we'll work it out and let you know.
Yes, sir.
All right, thank you. You can go back with the bailiff.
No.
There's new cases. Let's have a warrant out for that. And Carlos Rowe was brought. Probably. Now about that is that she wants her to. Probably not. But we could.
Okay, Ms. Perazzo, you have Brandon Kreischen. Good morning, how are you?
We haven't had a case for mine that has been.
Good morning, sir. You're Brandon Kreischen.
Yes, ma'am.
And this is cause number 26, DCCR 1178. Mr. Kreischen is charged with murder. And what is the announcement?
Your Honor, there are a couple of things, couple of items that are missing, not that it's the state's fault that I need to request, and there's also a guardhouse video that I'd like to schedule a time to be with Mr. Creation.
Okay. And go ahead.
I'm sorry
Yes,
to
ma'am.
interrupt. I certainly concur with Ms. Perazzo about that. I am still in the process of receiving discovery. Some scientific lab paperwork came in a week or so ago. We made sure to add that to the portal. This also involves the conflict we mentioned to the court yesterday that we've resolved with another individual who was before you that is a family member. So now that we have cleared up that issue, if you'll recall what I'm talking about, and I can fill you in on it.
Yeah.
It would allow me the opportunity now, as is my custom, sit down with the family. I wanted
Yes.
to do that before the court first, before I set that meeting, but I would like a
Okay.
chance to do that, make sure if Ms. Perazzo, as she usually does, sends me a list of what she needs, we'll go through our files together.
Okay, well, sounds good. And so what we'll do is just get with Ms. Holmes and we'll have Mr. Creation brought over. You guys can watch
make
that
that
video down here in the jury room in the next couple of weeks and get everything hopefully together between now and that next court date. And we'll see where we are at the next court date.
Yes,
All right, you can go back with the bailiff, sir. And then you have Thaddeus McCray.
That is the correct. Lieutenant.
Yes.
So I
yes.
wanted to make sure that wasn't an issue before I
Okay.
put that meeting.
Yeah, I was thinking, I know I was supposed to remember something.
That's what that was.
Thank you. Morning, Mr. Smith. Good morning, you're Thaddeus McCray. And Mr. McCray, in cause number 26, DCCR 0399, is charged with the first degree felony offense of murder. There's also a MTRP that we're carrying along with that. And so what is the announcement on the murder?
So, Your Honor, I had requested some additional discovery from the state. They did provide that, but due to other scheduling matters and issues, I have not had an opportunity to review that with Mr. McCray. So if I could just have one more reset so we could.
So, is there anything else that you guys are waiting on at this point?
Not that I'm aware of.
Okay.
They have produced everything. but I-
Perfect. So what we'll do, this will be the last reset. Ms. Perazzo will be out to see you to go over everything that she has received from the district attorney's office, relay whatever offer there is. When we come back, if there's an acceptance of that offer, we'll take care of it. If not, we'll get you placed on the trial docket after that.
Yes,
Okay?
thank you so much.
Yes, ma'am. You can go back with the bailiff.
I'll just say that's right.
Oh, yeah.
Yeah.
Mr. Rojas, you've got sentencings on Brendan Ernest.
Morning.
Good morning. How are you?
Good. For now.
Good morning, you're Brendan Ernest. And Mr. Ernest was previously in court, look this way, pay attention to me. And cause numbers 26 DCCR 0429, 0430, and 0908. Entered pleas of guilty to aggravated robbery, obstruction or retaliation, and robbery. I've received the pre-sentence report. Have y'all both had an opportunity to review that report?
We have, Your Honor. Yes, sir.
In addition to that, I've received and reviewed jail incident reports. Have y'all had an opportunity to review those?
We have. Yes, Judge.
All right, I am not inclined at this time to accept this plea agreement, based on the information of the offenses themselves, as well as the additional information that the detective has relayed with regard to all of the things that Mr. Ernest has been involved in, as well as what he's doing out at the jail. So y'all want to talk to me about
And
how to
Judge,
change my mind?
I don't know that this is gonna change your mind, but I meant to object to the part of Officer Jackson's statement as far as any uncharged conduct that happened while he was a juvenile in 2023.
I think that it's relevant and it's information that's important for me to know. If he's had contacts just because he was a juvenile and certain people didn't follow through because he was a juvenile and wanted to give him that opportunity, I don't think he gets to now say, well, I didn't get in trouble, so because somebody was nice and gave him some opportunity back then.
Well, then what I would say, Judge, is this is a youthful offender. He's 17 years old. These are his first cases. Some juvenile history that like it was successful completion of probation. He's never been on probation as an adult for either a felony or a misdemeanor. The alternative, Judge, I know is prison. And certainly there's a lot of violent crime going on in our community. It's for a first offense. I have a hard time sending people to prison for their first offenses, even though these are serious offenses. Some of them do deserve to go to prison for the first offense, but a 17-year-old first contact as an adult, I would ask the court to consider following the agreement with some sort of, I know the probation recommends MRT. I've also talked with Mr. Ernest about ISF, and he's willing.
There you go. 17.
Yeah.
So here's my thought on something like this, based on the nature of these offenses and based on what he said to the police that day, which gives me a huge amount of concern. I'm not going to repeat the words here about what he said he was going to go back and do to that clerk. I'm not letting him out on today, not doing it. If a jury wants to do that, I'm not one to throw things on y'all know how I am about my trial docket. I'm not inclined to just throw things on the trial docket, but I think this is one for the community of Jefferson County to decide instead of us, because I'm not going to give them probation. If they choose to do that, then that's going to be up to them. But I don't think this is in any way someone deserving of probation, regardless of his age, at least at this time. If he had been not acting like a fool in jail, maybe I'd decide differently. But he hasn't changed anything. You haven't changed anything. I'm talking like you're not here. You haven't changed anything about your behavior. You're out in our jail, acting like an idiot with the rest of the youthful people out there, doing nothing but giving those people that are going to work every day crap. And if you think that's going to get you somewhere and you're going to get to go home today, now you see what it's going to do. It's not. You're going to get set for trial. And when you come to trial, if you're found guilty of these offenses, a jury's going to get to see all of that information about how you're acting at our jail. So you need to keep that in mind between now and when you come back to trial, because if you're going to be asking a jury to give you probation and you've been acting like this, highly unlikely. All right. So what I'm going to do is I'm going to set it on the trial docket. Mr. Ernest, Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and I'll appoint another attorney today who can begin preparation for trial a little quicker. Is that okay with you?
My decision.
Yep. If you want to keep Mr. Rojas, you can keep him. If you want to get someone else, you can ask for that as well.
Okay.
All right, so Mr. Rojas will begin preparation for trial. And, there's things, if y'all want to go to a jury for punishment only and accept responsibility, that's an option. But talk to him about that, but I'm not gonna do it. All right, thank you. I appreciate what y'all did, and I don't like getting involved too much in these
Well, I
negotiations,
mean, the
but
offer was obviously made because of his age.
sure, no, I completely understand that. And I know you didn't know probably all the information, Mr. Smith, once it came out in the pre-sentence report about some of the specific facts of the case, as well as some of that history that gives me concern, as well as this jail stuff. So, I'm not saying you shouldn't have given the offer. I'm just saying there's a lot of things you probably didn't know as well. So, all right, go back with the bailiff. Shannon Jones, Mr. Rojas.
There's no, I don't think.
Oh, not yet. Okay, I'll hold that. What about Lorenzo Thomas?
We need to approach and, well, it's Ms. Malpino's case.
Did Ashley step out?
She stepped out, she should be right now.
Okay, thank you. 4-2, you're charged with the state jail felony offense of theft with previous theft convictions, and that's from March 13th of 2026. Your indictment alleges that you were previously convicted of theft February 8th of 2012, and then again June 3rd of 2013. And how do you plead to that charge?
Yes.
Not guilty?
Guilty.
Guilty. And are those prior convictions true?
Yes.
Did you enter your plea of guilty and true freely and voluntarily? And did you plead guilty because you actually did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Jones is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find those 2 prior convictions true, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft with previous convictions, sentence you in accordance with your agreement to a term of 6 months in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you did waive your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas.
Yeah.
All right, good luck to you, sir. You can go back with the bailiff. And then you've got Lorenzo Thomas. Lorenzo Thomas. What are we doing on this one?
There's some new offenses.
We just need to put some time. Okay.
I just want to let you know what all it has in addition to the motion.
Okay.
Decide if we were just going to stay or go elsewhere.
Good morning, sir. Are you Lorenzo Thomas?
Yes.
And this is cause number 22-40120, and Mr. Thomas is on probation for aggravated assault with a deadly weapon. And there's a motion to revoke that unadjudicated probation. What is the announcement?
Judge, it's coming to the attention of the state through Mr. Burrell that the defendant has, in addition to the Jasper County cases alleged in the motion, a new offensive evading detention felony in Harris County. I believe felony, Harris County. There's an active warrant for that now. I can either file a first amended motion to include that now that we have that offense material. We can allow him to go on that warrant, whatever the court wants to do, or go through this motion and see where we are. And I will
I could still add it, but we kind of know where we were, whatever you want me to do.
I mean, I guess if it is this going to be the state's position based on all of that for me to revoke
Yes, it
the
will be.
probation, then I think I need all the information. So first amended would probably be the best way to go. I know getting officers from Harris County might be difficult, but my thought is let's get it filed.
Okay.
Get an offer, get whatever discovery materials you can get on that to Mr. Rojas. If there's an agreement at the next court date, great. If not, so we'll get pleas of true or not true and then set a hearing and see who you can get to come. Possibly, and if there's an agreement to take any witness on Zoom, we can still do that. Especially on these hearings, but if that would be up to Mr. Rojas, you guys, and I'm not trying to pressure you to do it, but y'all can visit about that. And if that's an option, we can take some certain things up that way as well.
Sure, I'll get it filed this week.
Perfect. All right, we'll just do a reset then for that. Thank you. Mr. Okay. And in the file, Ms. Rodriguez was examined for competency to stand trial by Dr. Capon. I received that report dated June 22nd of 2026. The finding in that report is that Ms. Rodriguez is currently competent to stand trial. Is there any other evidence with regard to competency?
No, Your Honor.
No, Your Honor.
Then at this time, I am going to find Ms. Rodriguez is competent to stand trial. We'll move forward and will she waive the formal reading of the motion?
Yes, Your Honor.
And Ms. Rodriguez, did you swear her in?
Yes.
Okay. Usually you don't if there's no paperwork, so I was just making sure.
Right.
Gotcha. Thank you. Ms. Rodriguez, in clause number 17-27256, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 16th of 2018 for injury to a child, elderly, or disabled individual, a second-degree felony, and that was a 10-year deferred probation. Is that correct?
Yes.
This motion alleges that you violated your probation. Count 1 alleges that you committed the new offense of terroristic threat, October 23rd of 2025 in Orange County, Texas. And is that true or not true?
That's not true.
Count 2 alleges that you committed the offense of harassment on October 23rd and 2025 in Orange County, Texas. And is that true or not true?
No, that's not true.
Count 3 alleges that you failed to avoid injurious or vicious habits as directed on December of 2025. You disrupted and created disturbances at the Tiger Hut in Silsbee, Texas by calling, harassing, threatening, and posting falsehoods on their business website. Is that true or not true? Count 4 alleges that you're behind in your court assessed fees as of March 26th of 2026 in the amount of $9,198.39. Is that true or not true?
That's true.
All right, then, did you enter your plea of true to count 1 freely and voluntarily? 4, I'm sorry, count 4 freely and voluntarily. And did you plead true to that count because it's actually true?
It's true.
Then at this time, I'm going to find count 4 true, find that you entered that plea freely and voluntarily. Reset your case for a sentencing hearing. We'll get an updated pre-sentence report done. Ms. Malfino,
Judge, Ms. French has a detailed witness list already prepared. I'll make sure that goes out whatever date the court gives me today. And if she's in trial and something else, I pay.
so that'll probably need to have a little bit, a couple of hours, I would think, not just a short.
Like maybe you have 4 witnesses.
Okay, so we'll get it set on a date when we have plenty of time. Anything that you think is important for Ms. Holmes to know, get that information to her. She'll present it to me on your behalf when we come back and we'll set it for a hearing.
Yes, ma'am.
Okay, you can go back with the bailiff. Thank you, Ms. Malfino.
What started as a routine probation hearing quickly turned into one of the toughest courtroom lectures of the day. The defendant admitted violating multiple conditions of probation, including failing to report, failing to provide required tax documents, and falling behind on court-ordered fees. After confirming that the admissions were made voluntarily, the judge made it clear she had every legal right to revoke probation and send the defendant to prison. But that's not the decision she made. Instead, the judge gave the defendant something many people never receive: a second chance. She explained that probation officers and the court were trying to help her succeed, not set her up to fail. Then the hearing took a much more serious tone. The judge brought up reports from the jail describing repeated problems with attitude and refusing to follow instructions. She didn't hold back. She reminded the defendant that being on felony probation means following rules, whether you like them or not. Respecting probation officers, jail staff, and everyone responsible for supervising you isn't optional. It's part of the deal. Then came the warning that changed the entire mood in the courtroom. The judge said she could sentence the defendant to as much as